everyone. This is criminal profiler Pat Brown, and this is part 3 of my 5-part series on Karen Reed and lay jury failure. And I don't mean lay jury failure just in this one particular case, but in general. I am for a professional jury system. I've stood by that for years. And I'm not going to get into the constitutional issues because people always argue about that. I'm arguing about the reality of why we stick with lay juries when they clearly are illogical. Okay, so today, this third part, I want to talk about not understanding the totality of evidence. Okay, so the first part was 12 people of a bus stop. How I point out that, instead of getting 12 trained people like we would in any other profession, for if you went to a doctor, you'd want a professional. If you went to a lawyer, you'd want a professional. If you go to college, you want a professional. But when you get accused of murder, you get 12 people of a bus stop who have no training whatsoever. Doesn't make sense. Check that out. Part 2 was a jury of your peers. What the heck is a jury of your peers anyway? So now part 4 after this one is going to be not understanding how things work. And part 5 is going to be how Americans really do not trust the jury system, the lay jury system. They really don't. And I'm going to show you why they don't, in spite of the fact they claim they do. So part 3 here is going to be not understanding the totality of evidence. All right, what does that even mean? What does totality of evidence mean? If anybody ever follows my YouTube channel and I examine cases, I talk about over and over again the totality of evidence, the totality of evidence. This is the big issue. And there should be such the totality of evidence should, in a court case, should get to the point where the totality of evidence supports so well the guilt of the defendant that there is no reasonable doubt. Now, if the totality of evidence is not very total, in other words, the totality of evidence is really weak, or there's some of the evidence really points the other direction, then that is reasonable doubt. But I'm going to read you first a comment I got from a lawyer on X. And then I want to read you what totality of evidence means. He said, is, quote, totality of the evidence a haughty way of saying, ignore what doesn't fit into your initial gut impression of the case that you have stubbornly clung to. You just hedge by writing ample evidence, as you must realize that blah, 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 blah. And he goes on. So basically he's saying that when I say totality of evidence, I'm only saying the totality I want to believe in, and I'm going to ignore the other totality of evidence. That is not what totality of evidence means. He just wants me to appear as though I didn't consider all the evidence. But here is what it really means. And most people going into court do not know this. I do not believe they're even. I'd be really wondering whether this is what a jury hears when they go into court. Now, mind you, I've never been in a court as a juror because I'm not allowed in a court as a juror because I'm a criminal profiler. Defense attorney will never allow that. So I've never seen the inside of a court as a juror. But I would like them to say these things at the beginning of the trial, and I do not think it's true. But here's what. This is a good, simple explanation. In a trial, the totality of evidence refers to the complete body of information. Understand, this is what the lawyer was trying to say, that it didn't mean, which it does. The complete body of information that is presented to the court. So you are considering what the defense attorney says, and you're considering what the prosecution says. You're listening to all the experts. It's all the evidence put together, every single freaking bit of it. The complete body of information presented to the court, which must be considered as a whole when making a decision, not in isolation. And this is the problem I saw with the Karen Reed trial. I'm not going to get into which juror said what. Again, I feel for all the jurors who put their efforts into, to sitting through this trial and doing the best they could under the circumstances, which they had no training and under tremendous pressure from everybody, especially those outside the courtroom. But I saw them choose things in isolation. In other words, I didn't understand this piece of evidence. Therefore, I'm going to say that's reasonable doubt. That is not how you determine a case. That is not how it works. If the glove doesn't fit, you must acquit. Remember that one? That was garbage. There was such a tremendous amount of evidence that said O.J. Simpson was guilty of the crime. Yet, well, actually, that was probably, the jury made a decision. Oh, yeah, well, see, the glove didn't fit. Okay, it's probably a racial thing, too. But, there were, again, emotions and other political issues that were all wrapped up in that case that had nothing to do with the evidence. Let's go to Caylee Anthony, which had no racial issues, no gender issues, pretty much, no gender, just no basic issues, except for Caylee Anthony was murdered. And Jose Baez was a great defense attorney. I consider him a scumbag, but hey, he's still a great defense attorney. If I were in her shoes, I'd want him too. Who are you going to get? The person that's going to get you off. And what did he say? He brought up some idea in isolation that her daddy might have drowned Caylee in the pool. And the jury's like, well, that could have happened. That's an isolated claim. That is not even proven. But they're saying, well, since I don't know, might be true. Therefore, maybe it is true. What about the totality of all the evidence that points to Casey Anthony killing her child? Where the totality, you could write dozen columns, about the evidence that points over here, and just you picked out this one thing in isolation. So I saw some people in the Karen Reed case say things like, well, I don't think he was hit by a car. Or I thought the scratches on his arms looked like dog scratches. That's isolation. What about all the other evidence? All the other evidence, the totality of all the other evidence. You didn't understand one thing, a couple things, but all the other evidence pointed elsewhere to something that happened right there on the front lawn. All the other evidence had him. No proof he ever went into the house. No proof he was actually attacked by a dog. No proof that anybody murdered him. No proof anybody came out and threw him on the front lawn. No proof that he ever moved hardly a step with his phone from the location where the car, in my opinion, hit him. And where Karen Reed says, I might have clipped him. All of these things, and I'm just throwing a couple of them out there now, but all of these things, the totality of the evidence didn't leave much room for reasonable doubt, except when you don't understand totality of evidence. But again, the jury doesn't understand that. And the defense attorneys definitely don't want you to believe in it. Defense attorneys are more into shadow of a doubt. And a shadow of a doubt means if you have any inkling that you don't understand one thing, then the prosecution didn't prove their case. That's the way they like it. So it goes here further. It emphasizes totality of the evidence, that individual pieces of evidence should not be viewed in a vacuum. Oh, God, I just love that. Should not be viewed in a vacuum, but rather in the context of all other evidence. And that's where you start putting everything together and you say, alone maybe, but when you put the other 5 things with it that are there, then it's pretty obvious. This principle applies to both circumstantial evidence and direct evidence, and is crucial for a fair and accurate assessment of the facts. It's an AI overview, and thank you, AI, for that is absolutely exactly a very, very perfect description of what totality of evidence is. It says further here, totality of evidence approach requires the court to consider all the evidence presented, including witness testimonies, documents, physical evidence, and any other relevant information. Contextual understanding. The judge or jury must analyze every piece of evidence in light of the other evidence. Not just saying, oh, I'm going to ignore all the other evidence and just go with this one piece. Understanding how they relate to and support or contradict each other. Avoiding isolation, this principle prevents the court from focusing on a single piece of evidence and drawing conclusions based solely on that, which could lead to a biased or inaccurate assessment. Because there's always, I'm going to get to this in my last, the part 5, which is, part 4, my next one actually, how things not understanding how things work. I'm going to get to that right there. Not understanding how things work. So you don't want to base something just on one little piece of evidence because you think that means something, or you don't understand it. So therefore, fact finding. The totality of the evidence is essential for establishing the facts of the case and determining whether the burden of proof has been met by the party presenting the evidence. All right. I absolutely love this. For example, in a criminal trial, the prosecution might present evidence of a weapon, motive, and opportunity. A totality of the evidence approach would mean the jury must consider all these pieces of evidence together to determine if the defendant committed the crime, rather than just focusing on the presence of the weapon alone. Well, that's so. They're in this particular instance, they're saying, hey, just because a guy's a gun and a guy was shot doesn't mean the gun shot the guy. However, if you hear 3 gunshots, bang, 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 and that defendant was seen running from the house with his gun in the air, shouting, "I killed the bastard," and there are 3 bullets missing, that's pretty good evidence. Of course, you're going to say, well, that's easy because then the bullets will be in the guy, right? I admit that's very simplified. But the point being that there is a totality of evidence, and then you've got maybe a piece of evidence. For example, let me give you a different example before I sign off. All right, same example. A guy runs from a house with a bloody knife in his hand, and he is screaming, "I killed the bitch. I killed her. I killed her." Later on, I found out that the woman indeed in that house indeed is dead, and she also so they get DNA from her. And she has been sexually assaulted. But the DNA comes back to not matching the guy that was running from the house with a bloody knife. What does that mean? Well, is that reasonable doubt? Oh my God, well, it's not his DNA, therefore he didn't do it. Yeah, but you saw him. People saw him running out of the house with a bloody knife, screaming he killed her. And the knife, he washed the knife off. So now the actual blood, there's no blood shown on the knife now because he really did a great job on it. So now, but the knife does fit all the wounds. But the defense attorney says, but the knife, just because a knife fits through the wounds doesn't mean that it was that knife. It could have been a different knife, which is true. It's true. It could be 2 people can have the same kind of knife, right? And so, but since there's no blood on it that we can prove was her blood, therefore we can't prove it was the knife. And then people say, well, what? The prosecution says, what about the guy running from the house at the time that she died? And he goes, well, he might have just simply freaked out when he got in there. He said, oh my God, I've run into a woman who's dead. And I happen to have my own knife. And so I was scared. So I pulled the knife out. This is what the defense attorney does. He comes up with some story. He pulled his own knife out because he was afraid because the killer might be in there. And then he ran out and he was screaming stuff. But these are only witnesses and we don't have a videotape. And he didn't really scream, I killed her. He was screaming, somebody killed her. And they misunderstood what he said. And then his DNA wasn't there. And so is that reasonable doubt? Well, first of all, maybe the woman was in the business and she had a customer prior to this guy. Somebody else's semen is there, but she's not going to talk about it. Well, she's dead. He's not going to talk about it because he's not going to say, that's mine. He's not an idiot. So he's going to, if his DNA isn't in the system, he's shutting up. So now you have the jury in there and they're like, they're listening to the defense attorney and saying, well, his DNA wasn't his DNA. So in spite of the fact he was seen running out of the place with a knife that would have caused those wounds, screaming he killed her. And by the way, he's been in prison twice before for stabbing women. We're going to say that because of that DNA, we're going to find reasonable doubt. Is that really reasonable doubt? So this is where you need a professional jury to say, okay, I'm not going to be fooled by the defense attorney, but I am going to consider the point that there was DNA from somebody else. What does that mean in the totality of the evidence? Not in isolation. Let me just look over here. So DNA doesn't match the guy. End of story. Let's ignore 10 other pieces of evidence. All right. Or do we look at all those other 10 pieces of evidence, which clearly show, and I only showed 3 or 4 of them, there's 6 more, and all of those things put him there at the scene with the knife, with the motive, whatever. But the defense attorney says, but if his DNA isn't there, you must acquit. And the jury goes, oh, I don't know. Maybe the defense attorney's right. Okay. We'll find him not guilty. You have to understand the totality of the evidence. And this is something that every jury should understand, but I don't think a lot of juries do. And they also have to understand that there's a difference between reasonable doubt and a shadow of a doubt. You know, if you're going to go with a shadow of a doubt, which you should never, that means that you could say, there's no way on God's earth, barring a videotape. And, to the point where, maybe the videotape could have been fudged too. So, you can always come up with seven different reasons why something could not be the way it is. And in today's world, that's what defense attorneys do. And they make it more and more complicated for any jury to look at the evidence and say, hey, there's enough here to say this person committed the crime. Instead of, they say, look for the one little piece of anything that's confusing to you, and that should be enough for reasonable doubt. And that's not what reasonable doubt means, but that's how it's presented. And for 12 people on a jury, and you only need one to say, maybe, then as long as a jury, in a lot these certain cases, there's cases out there where, the guy committed the crime. It's so bloody obvious he did it, and he's got a public defender who doesn't really work that hard. He only gets paid so much, so he doesn't get the fancy expert and all that crap. So he just does his job and goes home. And nothing against public defenders. I'm just saying, you probably actually do it correctly. Just saying. Whereas Jose Baez is paid so freaking much money or gets so much publicity, he can pull out all the stops. So the normal jury that comes in for a fellow in town that nobody cares about, that's a reality too. You got a guy who's a low-life drug dealer in the town. He's been in and out of prison for his entire life, and then he ends up killing somebody, and the jury's like, yeah, he did it. It's pretty obvious he did it. Sometimes he actually didn't do it, but you get somebody like Karen Reed, and you get the entire internet, and everybody for her, and all this kind of crap, and it becomes a circus. And when you're inside that circus, it becomes so much can be presented wrongly, and presented incorrectly, and presented in a way that is confusing, that the jury just says, oh, I'm not going to be the one to find this person guilty. And I think that's what they did with Karen Reed. Okay, so that's the end of this. And the next topic is going to be not understanding how things work. See you there.